Snape. I'm an associate solicitor at Stephensons Solicitors, which is a national law firm. I'm based in our regulatory team, and I represent a wide range of individual professionals as well as businesses before their regulatory bodies. That generally includes those in health and social care sectors, as well as the education sector and many others. The majority of my clients are regulated by Ofsted. I represent and have represented those who are facing investigation by Ofsted, specifically in relation to the issue of unregulated and unregistered provisions, as well as advising generally on whether organisations require registration. I'm joined by Alice de Coverley, who is a barrister at 3 Paper Building Chambers in London. Alice specialises in education, equality and public law, and she regularly acts on behalf of children and young people, vulnerable adults, parents and carers, schools, local authorities, charities and NGOs, as well as government departments, students and universities. Alice has also worked closely with Ofsted, providing specialist advisory and advocacy services in all areas that Ofsted regulates and inspects, and that included combating illegal and unregistered schools. So we are looking at the Department for Education's consultation into the reforms to unregulated provision for children in care and care leavers. The consultation has ended and the government have issued their response to the consultation in February. The consultation focused on the increase in the use of independent and semi-independent settings in children in care and care leavers. And as a result of this increase, the government wanted to look at scrutinising this type of provision more closely to ensure that it's used appropriately and provides the right level of support and safety. So, Alice, can you talk us through the difference between unregulated and unregistered provision? I think sometimes it can be confusing, the two terms that are used.
Yes, I absolutely agree that these two types of provision can sometimes be confused. So taking unregulated provision, this is provision that is allowed in law. It means provision that is not regulated by Ofsted. And just because it's not regulated by Ofsted, that doesn't make it unlawful. So unregulated provision in our context for this podcast means where children need support to live independently rather than needing full-time care. So unregulated provision previously included those under the age of 16. And this is the change that we'll be discussing later in the podcast that comes into force in September 2021. And this type of provision is often described as a stepping stone to independence for children who do not want to remain living in a children's home. Usually this is supported living, where the local authority is responsible for ensuring that such placements are safe and are suitable for that child. By contrast, unregistered provision is where a child who needs care is living somewhere that is not registered with Ofsted. The emphasis here is on a child who needs care. If a provider delivers a care element as well as accommodation, it must register as a children's home. If it does not do so, it will be operating illegally. So what this means is that the key difference between unregulated and unregistered provision is whether you as a setting are providing care. And that means any care, rather than a set number of days. I don't know if, Francesca, you've had any myths about the number of days that often means that you are providing care. I've seen 28 days, 21 days and so on. But the reality is that there's any care that's being provided to that child. And then when you have that registration, that then results in the need for inspection and oversight from Ofsted. And they have that aim of making sure that all children are kept safe and standards are kept high in those registered settings.
Yeah, I agree. I think there's been a lot of confusing myths, like you say, about the amount of days. And I think this a term around whether it's an emergency placement has sometimes caused confusion, but it really does come down to the type of service that you're offering to those children, and it can often be quite a case-by-case basis of whether you're providing care as well. So it needs to be looked at very closely. So in what circumstances might a provision be able to operate an unregulated provision? So as you've just explained, that you can lawfully operate an unregulated provision.
Yeah, so typically we see supported living for children and young people being the main way that unregulated provision operates. And this would be where the local authority acts as the corporate parent to ensure that placements are safe and suitable for that child. So that's the main way in which you might see provision operating on in an unregulated sense. I don't know if, Francesca, you've seen other types of setups that you might also describe as unregulated provision.
That is generally the type of provision that falls under that definition. Again, I think any case would need to be looked at very specifically as to what type of care, but I think the general consensus or view, certainly maybe of Ofsted, is that if it's a child under 16, they are probably going to have higher needs than a 16 or 17-year-old, and are therefore more likely to fall into that definition of care. But obviously every case needs to be looked at on their own specific facts. What are the potential consequences of operating an unregistered and therefore potentially illegal provision?
So Ofsted deals with both settings that don't know they need to register, and those other types of settings who actively seek to avoid registration. So there are often a range of different reasons why a setting might not be properly registered. In any event, Ofsted can take enforcement action against illegal unregistered providers, and that's currently through prosecution. It is a very serious matter to have an illegally and unregistered provider. And Ofsted has a similar task force in place at the moment for unregistered schools. So, for example, in one school recently prosecuted by Ofsted's task force, the finding was that none of the adults working with children had been checked at all for their suitability to work with children. So that is one example, and that school was shut down. And so the DfE, the Department of Education now, the DfE, is moving forward with plans to give Ofsted additional powers to take enforcement action at an earlier stage. So this will enable Ofsted to move more quickly to close down or register settings through enforcement notices before proceeding with prosecution. So that increases the arsenal of approaches that Ofsted can use to deal with these types of settings rather than going straight to prosecution. They have a range of options now in the future, well, will be coming up to be able to deal with these types of settings. And in my view, I think that will help to deal with those circumstances where you have providers who did not realise that they needed to be registered because of the, as you say, circumstances of the case that they are looking at, rather than they are intentionally trying to evade the regulator.
Yeah, I think all this confusion about the type of setting has led to a lot of providers unknowingly breaching the legislation. I think Ofsted recognise that as well. In my experience, they generally sort of send a warning letter when they come across a provision that might be operating illegally. So they do sort of give a warning, but it seems that it's a warning and then they have no other option but to proceed with the prosecution if they can. But I do think that they recognise there is this confusion. So looking at the proposals that have come out as a result of the government's response to the consultation, firstly, can you just talk about the key responses to the government consultation?
Yes, so this was an online consultation held during the pandemic last year. Well, it started in February last year and ended in June 2020. So it lasted for 8 weeks. And there were 230 individual and organisational responses. And of that included 160 care experienced young people's responses as well. So that voice was certainly, I think the government would say, present in the responses. And the vast majority of those responses agreed that a child under 16 should not be placed in a setting that does not provide care, which is intended to facilitate independent living. And the consultation also explained in their response that they received many examples of good provision, but they also received plenty of examples of low quality provision, particularly in the area of independent and semi-independent provision.
Yeah. And can you just talk us through what reforms the government have announced as a result of the consultation?
Of course. So the Department of Education's response to the consultation makes clear that while independent and semi-independent provision can be the right option for some older children where it's high quality and meets their needs, children aged under 16 are often simply just too young for this type of accommodation. which is intended really to facilitate supported living for older children developing their independence before they leave the care system. And the DfE concluded that this practice places children at risk of harm and isn't something that can be sustained. So what they are then going to do is ban effectively under 16s being subject to this type of unregulated provision. Importantly, this doesn't include all types of settings that might potentially be seen to be covered here. So, for example, CQC registered residential care homes, hospitals or other settings providing medical care would be exempt from the ban. And so too for anyone who is listening who deals with special educational needs, so too with DfE or Ofsted regulated residential schools providing accommodation under Section 89 of the Children Act 1989. So those sorts of settings would be exempt from the ban, but generally speaking, it is that sort of below 16 that would no longer be able to have this type of unregulated provision. And this ban will come into effect in September this year, following a grace period to give local authorities time to respond to the changes and make alternative arrangements. And I probably would say it's also part of a big drive to improve standards across the country. So I don't know if any of our listeners have seen, but there's an independent review into children's social care, which was announced in January this year and was launched formally in March this year. And that's chaired by Josh McAllister. And that review is looking at a whole range of different issues in the social care system, but with particular focus, it seems, on the voice of those who have had experience of the care system. And I noted that they did have an experts by experience board that they are using, which includes children, young people and adults, and families who've experienced the care system as part of that review. So, as I said, it does seem to me that be part of that drive to increase standards. And this is why the government's also looking at introducing national standards, so sort of like your national minimum standards, NMS, for unregulated settings that are accommodating 16 and 17-year-old children in care and care leavers, to raise the bar for the quality of this provision and to ensure consistency across the country. And then, as with other more regulated settings by Ofsted would then oversee those standards via its registration and inspection regime. So those are sort of the key bits of the reform that the government is trying to introduce. And then there's also increased enforcement powers that we've discussed as well. So rather than reaching straight for prosecution, there are a number of newer steps that are being introduced in between that. Are there others that you wanted to mention, Francesca? I know that before this podcast we were talking about there being potentially other consultations about standards being changed or improved in other areas.
Yeah, so I think the consultation now about these national minimum standards for 16 and 17 provision, I think that's open now. I think it's open until July. And they've asked both children in care leavers and people operating or people in children's social care organisations to respond to that as well. So I think that'll be really important. Like you said, it's a drive, isn't it, to improve standards. So I think the ban on unregulated for under 16s, it stops, and they haven't gone as far to ban that for 16 and 17-year-olds, but they are looking at tightening up the standards expected for those types of provisions through this current consultation that's ongoing. I mean, in my view, sort of the biggest impact really is going to be on local authorities, because they've been using these types of provisions to place children. And I think at the moment it's sort of, it's no secret that there are sort of a lack of places in children's homes for children in care. So in practice, what's your view in terms of the impact those changes will have for those involved in children's social care in the country?
So I would say that the headline's probably that it will generally help. So it's always helpful, I think, to have improvement in clarity in legislation, in guidance, in statutory guidance and so on. because then that can help ensure that local authorities and other decision makers can make more speedy choices about where they might need to change, place children in emergency situations, or in situations where they need to make a quick change of provision to ensure that that child's needs are met if those needs have changed, that sort of thing. So it is, I would say, probably going to be helpful in that respect, with accompanying statutory guidance, for example, on the role of the independent reviewing officer, something else that they've signalled might be in place. But as I completely agree with you, the downside appears to be concern about lowering the supply of potential placements for local authorities. This is a huge problem in many of my cases, whether I'm working for local authorities or whether I'm working for families or actually also providers, where local authorities are struggling to place children in any suitable accommodation in the county, let alone near that child's sort of community.
Yeah.
So that does seem to be a concern. But I suppose I would counter that by saying that it's also about quality, not quantity, when you're doing something so important as to care for and accommodate a vulnerable young person. But in terms of other kind of positives and negatives, costs is also a huge hurdle. So as you all know, you need capacity and resourcing and often legal advice to keep up with changes in standards. And we know that many providers have exited the market as a result of these changes, and that sort of need for periodic review of whether or not they've complied with the relevant legislation. And that's a burden, that's difficult for many providers. But I suppose I would say probably overall, it's preferable to have higher standards being met across the sector, and that local authorities might be more willing to use providers that meet those standards and only those types of settings, in the same way as you might have local authorities that have a general policy not to place a child at an inadequate school.
Yeah.
In the same way you may have decision making about when that child might be accommodated if necessary. So I do think that is going to be quite helpful and important. And then, as we said, rolling right back to what we were saying at the start, knowing whether something needs registration or not is going to be very useful, because there is difficulty in knowing whether what you are doing is something that needs to be registered. And I think that having an improved model for national standards, Ofsted registration for this type of provision in future would hopefully better define this type of provision, making clear that distinction between the children's home and a legitimate independent or semi-independent provider. So overall, I think it is a positive, but I do utterly and completely recognise how difficult it's going to be for a huge number of listeners to ensure that they are up to date and up to speed with all of these changes coming up, particularly given the pressures on the sector at the present time.
Yeah, I agree. I think in the consultation, in the response as well, the government said that they were aware of the local authorities that relied heavily on these types of provisions, and that they were going to specifically provide quite intensive support for those local authorities. So hopefully that goes some way in addressing any needs that those local authorities have that maybe rely more heavily on those types of provisions. But yeah, we'll have to see how that plays out and whether that support is going to be sufficient.
Absolutely, I agree.
What are sort of the positives and the negatives to the proposals? You have touched on a few already then, but are there any others that you can think?
I think what we don't know yet is exactly what those new standards will be. So I think that at this point, I'd probably encourage all listeners to engage with any kind of consultation on the particular consultation you have mentioned, and to watch out to see whether or not the DfE does a wide consultation on those, because it's clear from all kind of public consultations in general, not always, but in general, that they are willing to listen to those who are providing the work on the ground. So if there are standards that are being recommended or changed from what's already in place, that you think won't work in practice, or are too much of an overkill, or are not getting to the point, then it's really useful as an opportunity to say, this is exactly why it won't work, and it's well intended, or it's just plain wrong, or it's not backed up by research, or whatever, to actually say so. But I suppose at this stage we don't know precisely what that kind of arrangement is going to look like, and it might be that some of it is not going to be as it might be misguided, or might be not tackling the issue that it says it will. So I suppose the other thing I'd say is just to encourage participation in those sorts of public consultations as well, and often with evidence as well. If you have evidence from your own experience, or providers you've worked with or work at, to say why it doesn't work, or why it does work in support of that change, then that can be incredibly helpful to those who are making those higher level policy decision changes, and changing legislation as well.
Absolutely, I agree. I think, like you said, it's going to be that clarity, isn't it, that has caused a lot of issues as things currently stand. I know generally, I'm involved in cases where it's not clear cut whether registration is required. So I think that clarity will just assist, and will hopefully avoid Ofsted needing to investigate in some circumstances as well, because it's quite clear. I think, as well, a lot of the cases I've dealt with, organisations have generally benchmarked themselves against the standards, even if they aren't registered. So hopefully most organisations, and I think the consultation acknowledged that a lot of the provisions they came across did meet high standards, but hopefully then it will provide clarity for those who don't as well. So there is going to be some burden on unregulated provisions that now need to register, and going through the registration process, and that can be quite a difficult process to go through, especially if you've not been through it before. But yeah, we'll have to see how Ofsted deal with those.
And I agree. I mean, it's difficult at the moment because there has been a year and a half of delays to the whole system. So it might be that those decisions about registration take longer. There's going to be more settings that are now looking to become registered settings, although, as I said, others will be exiting the market, I think, or recalibrating themselves in some way. So there may well be some delays as well in achieving that registration, which makes it tricky to then place beforehand. So, and as I said, local authorities are pretty mindful, in my experience, of making sure that the setting is the right sort of setting before doing so, particularly in cases, like I said, in the first year tribunal system, where the judges are often very keen to ensure that the child is going to a setting that is proper and registered and sufficient, in exactly the same way as they would if it was a school that was not yet registered.
Yeah.
Similar sorts of standards are starting to be applied to the social care parts of education health care plans as well.
Yeah, absolutely. It'll be interesting to see, certainly after September, once the ban comes into place, how sort of the regulatory landscape plays out. But yeah, I think I agree with your assessment that generally the announcements are positive, and I think they're backed by the sector as well. So yeah, that would be interesting. Thank you, Alice, for joining me, for answering those questions. It's been nice to speak to you.
You too. Thank you so much.